Hello and welcome to BYJU'S IAS. Let's get started with the analysis of today's The Hindu newspaper, beginning with a news item on page number 7 of the Delhi edition of The Hindu relevant for GS paper 2. Anonymity of poll bonds must go, says the Election Commission of India before the Supreme Court, because the Supreme Court is hearing the validity of these electoral bonds. But now let's look at this newspaper article in great detail. We have Article 326 of the Indian Constitution, which talks about right to vote. So right to vote is a constitutional right under Article 326 of the Indian Constitution. Initially, it was supposed that right to vote is a statutory right provided under Representation of the People Act 1951. But now the Supreme Court has made it clear that right to vote is a constitutional right provided by the Constitution. But we also have Article 19, Clause 1, Clause A of the Indian Constitution, which is a fundamental right. And this fundamental right talks about freedom of speech and expression. But one right within this freedom of speech and expression is a right to make an informed choice. What is this informed choice? If I have to take a decision, if I have to make a choice, this choice should be based on the information. Otherwise, my choice or my decision will be ill-informed or misinformed. So I need this information. So far as a voter is concerned, is there any link between the right to vote as a constitutional right and freedom of speech and expression as a fundamental right? Yes. Because when I'm making a decision, I want to cast my vote. This decision should be based on some information so that I can make an informed choice. And what is this information? I should know whether a candidate is educated or not. What is the educational qualification of a candidate? On that information, I can take a decision. What are the criminal cases pending against this candidate? What is the amount of assets in the name of this candidate and in the name of the spouse of the candidate? So that on the basis of this information, I can make an informed choice and I can cast my vote in the Indian elections. That is the link between right to vote and the fundamental right of freedom of speech and expression available to every single citizen of this country. But now, if I know information about the candidate, but this is only half the information. I should have the information about the party as well. And what sort of information I require? Who funds this political party? Because let's say, for example, I believe in environmentalism. So I want to vote for a political party A which also believes in environmentalism. But what if I come to know that there is a company or there is a corporation which has a history of being anti-environment, and this company is providing funds to this political party? I will make an informed choice that I will not vote for this political party, because tomorrow when this political party comes to power, this political party will give some benefits to this company and this company will violate the environment. But now who funds this particular political party through electoral bonds will never be known to the individuals. The funding to political parties through these electoral bonds is all opaque, is all anonymous. And that is why the petitioner argues that electoral bonds should be declared null and void by the judiciary, and Election Commission supports this argument that anonymity of these poll bonds must go. Because let's assume that there is a company which is donating money to this political party A. There is no free lunch in this country. There will be quid pro quo. That means if a company is providing funds to this political party will provide contracts once it comes to power, will provide some licenses to this company. So there is always a quid pro quo involved. So voters should know which company or which corporates are funding these political parties so that they can make an informed choice. But now let's look at and how these electoral bonds work. Let's say, for example, I am a donor. I want to donate money to a political party. What I can do, I can approach the State Bank of India. And State Bank of India will issue a bond to me, an electoral bond. Now this name electoral bond is basically a misnomer. Why? Because when you buy a bond, interest is also paid on that bond. But on this electoral bond, no interest will be paid. I am a donor. I approach the State Bank of India either through check or through digital transaction, and I buy this bond. What is the value of this bond? It can be 1000 rupee, it can be 10,000, it can be 1 lakh, it can be 10 lakh, it can be 1 crore. And when this electoral bond is issued to me, I can deposit this electoral bond in the bank account of the political party of my choice. But this bank account should be with a registered bank, that means will come under the ambit of Reserve Bank of India. But for which political party I can deposit this electoral bond into? Any political party which has polled at least 1% or more votes in the last assembly or Lok Sabha election. That means any political party bagging less than 1% votes, they cannot get these funds through the electoral bonds. And this political party has 15 days to encash this money. But this bond is a bearer bond. And what do we mean by the bearer bond? That means when A is buying this electoral bond from State Bank of India, then depositing this bond into the bank account of a political party, the donor is anonymous. That means not even the political party knows which corporation or which industry or which individual has donated this much amount of money into my bank account. So if this entire transaction is opaque, anonymous, how can citizens make an informed choice about which political party they should vote for? That is why these electoral bonds should go. But there is a bigger problem associated with these electoral bonds. According to newspaper reports, 1700 crore worth of these electoral bonds have been deposited into the bank accounts of various political parties. And majority of this money has been deposited into the bank account of the ruling political party. How? This is where the deeper problem with the electoral bonds lie. How? This is a government and State Bank of India is a public sector undertaking. So if this company A wants to buy this bond, State Bank of India officials can communicate this to the government, that there is a particular individual who has bought an electoral bond worth 1 crore rupees. That means who will come to know about the identity of this donor? The government. But then this donor has to deposit this bond into the bank account of a political party. Now you can say, how will the government come to know into whose bank account I am depositing this electoral bond? Because this bank account is regulated by the RBI. And we have seen how institutions have been under assault, not just in the current government, all governments, successive governments have assaulted our institutions. And now some official of the RBI can communicate to the government, to the ruling political party, that there is an individual who has deposited this money into the bank account of the opposition political party. And then what the government can do? Government can misuse its other agencies. Enforcement Directorate, CBI, Vigilance, so on and so forth, and victimize this donor that why are you donating money to the opposition political party? You should donate money to us. That means in all this entire exercise, the biggest beneficiary is the government, is the ruling party, which is ruling the country at that point in time. So there are two basic problems with electoral bonds. Number one, the poll donations are anonymous, and which goes against the fundamental right of making an informed choice under Article 19 of the Indian Constitution. And at the same time, it violates a level playing field because the ruling political party will ensure that we should starve the opposition political parties from donations. That is what you need to understand from this newspaper article. Now let's look at another news on page number 1. Supreme Court rejects centre's plea to keep Rafale documents secret. Now let me give you a slight background about what this issue is all about so that you are in a better position to understand this newspaper article. In 2015, Prime Minister Modi on his visit to France announced a Rafale deal where 36 Rafale fighter jets would be provided to the government of India in a flyaway condition. Who is the manufacturer of these Rafale jets? French aviation company Dassault. But there was one interesting clause in this deal, and that was offset clause. And what is this offset clause? Let's assume the total value of this Rafale deal is 60,000 crore. The offset clause is set at 50%. That means what is the 50% of 60,000 crore? 30,000 crore. This Dassault, who is the manufacturer of Rafale jets, it has to provide 30,000 crore worth of contracts to the Indian companies. So if Dassault bags a contract worth of 60,000 crore, 30,000 crore worth of contract should be provided to Indian companies. And one of the biggest beneficiary under this offset clause was Reliance Defense. Reliance Defense would have been provided some amount of this contract, which means Dassault will give contract to Reliance Defense under this offset clause, if not the entire 30,000, let's say 10,000 crore worth of contract. That means Reliance Defense will not manufacture equipments for this Rafale jet, but maybe Dassault will give a contract of worth 10,000 crore to Reliance Defense so that you can manufacture equipments, and these equipments we can use in our business jets, Rafale's business jets. That means under this offset clause, 30,000 crore worth of contracts should be given by Dassault to Indian companies. Then there was a controversy why Reliance Defense was chosen as one of the offset partners and not Hindustan Aeronautics Limited, which is a government company. It was alleged that Reliance Defense has no experience whatsoever in defense manufacturing. Instead, this offset contract should have been given to HAL. Many people alleged that there is some element of corruption involved in this entire Rafale deal, and few petitioners approached the Supreme Court. Arun Shourie, Yashwant Sinha, Prashant Bhushan, they approached the Supreme Court that there should be an investigation into this Rafale deal, and they were seeking some information. Information such as what is the price of a Rafale jet, how have you decided upon an offset partner, who can choose the offset partner? Is it the Dassault's independent decision to choose an offset partner, or was Reliance Defense chosen by the government of India as the offset partner of Dassault? All these controversies, and when Supreme Court heard this matter, Supreme Court rejected this petition and said there can be no investigation into this Rafale deal. Why? Before Supreme Court gave this decision, Supreme Court asked the government, please submit in a sealed envelope the details about the Rafale deal so that we can check the contents of this sealed envelope to see if there is an element of corruption so that we can order the investigation. Why sealed envelope? Because the central government said if we are going to provide you the price of this Rafale jet, then our enemies will come to know what is the specification of this Rafale jet. And it will be a national security nightmare for us. It will be a boost for our enemies. They will come to know about our war preparedness levels. That is why we cannot provide you the specifications. And in this sealed envelope, so that no one else looks into the contents of this envelope, we will provide you the specifications and details about this Rafale deal. And Supreme Court dismissed this petition of the petitioners and said there can be no investigation into the Rafale deal. How did Supreme Court reach to this conclusion that there can be no investigation into the Rafale deal? Supreme Court said that the government has said in the sealed envelope that CAG has already prepared a report on this Rafale deal, and then this report has been tabled before the parliament. So if all the details are available already before the parliament, so why should there be an investigation into this case? When the Supreme Court gave this ruling, petitioners argued that the government of the day has misled the Supreme Court. Government of the day has lied to the Supreme Court because CAG has not published any report on the Rafale deal, and such a report is not even tabled on the floor of the parliament. Then government of the day approached the Supreme Court again and told the Supreme Court that, dear Supreme Court, you have misinterpreted the contents of this sealed envelope. We didn't say that CAG has published a report and this report has been tabled on the floor of the parliament, but what we said, the money for these 36 fighter jets would be paid out of the Consolidated Fund of India, and all the expenses paid out of the Consolidated Fund of India will be audited by the CAG, and then CAG will prepare a report and present this report before the Parliament. We have said that CAG will prepare a report and present it before the Parliament. We didn't say that CAG has already prepared a report and presented before the Parliament. So this is how government approached the Supreme Court again, requesting the Supreme Court, please modify your earlier order. Then came some revelations. And these revelations were published by N. Ram in the Hindu newspaper, wherein N. Ram argues that there are documents which N. Ram has accessed, and through these documents we can safely assume that there is an element of corruption in the Rafale deal. N. Ram cites that there was one communication between the Prime Minister's office and Dassault and the French government, and there was a parallel deal going on between the Defense Ministry and the French government or the Dassault. So why there were parallel negotiations going on the same deal? This points to an element of corruption, number one. Number two, was Cabinet Committee on Security consulted when Prime Minister Modi announced this Rafale deal? Because according to defense procurement norms, any defense deal worth more than 1,000 crore should be approved and okayed by the Cabinet Committee on Security. Was this done, or did Prime Minister unilaterally approve or announce this Rafale deal without any concurrence from the Cabinet Committee on Security? And then these petitioners approached the Supreme Court again and said there should be a full-length investigation into the entire Rafale deal so that the truth comes out in the open, the truth comes out in front of the public. But then the government argued before the Supreme Court that these documents cannot be treated as evidence. Why? Because these documents have been stolen from the Defense Ministry, and a stolen document cannot be treated as an evidence before the court of law. Later on, the government modified and said, no, these documents have not been stolen, but these documents accessed by NRAM, they are Xerox copies of the Defense Ministry. Now the Supreme Court, before it can decide, yes, we will hear the review petition against the Supreme Court order, we have to first decide whether these documents can be treated as an evidence in the court of law or not. In your GS paper 2, there is a topic called Comparison of the World Constitutions. If we look at US Constitution, if there is a stolen document, this stolen document cannot be treated as an evidence in the Supreme Court of United States because it violates 5th Amendment of the US Constitution. But in India, there have been 2 judgments in the past, and now there is a yesterday's judgment wherein Supreme Court has said if this document is relevant in a case, it doesn't matter where this document is sourced from. Whether it is a stolen document, whether it is a Xerox document, doesn't matter. If this document is relevant in a particular case, we will treat this document as an evidence. And now the Supreme Court has said this document, which has been accessed by the Hindu newspaper, whether through Defense Ministry or through other sources, these documents can be treated as an evidence, and based on these documents, we will now hear the review pleas against its original judgment in which earlier Supreme Court said there should be no investigation into the Rafale deal. And now there will be a review petition, and then the Supreme Court will decide whether there can be an investigation into the Rafale deal or not. That is what you need to understand from this newspaper article. But there are 2 important things that you need to know. Number 1, Supreme Court was told by the government that these documents are official documents, and under Official Secrets Act, these documents cannot be accessed by Right to Information Act. That means you cannot file an RTI application to seek information about these documents because under Official Secrets Act, if it deals with matters related to national security, we will not be in a position to share the information. But in a landmark ruling which will have far-reaching consequences on the role of RTI in this country, Justice K.M. Joseph has said that RTI Act supersedes Official Secrets Act. The judge said that RTI Act confers on the citizens the priceless right to demand information even in matters affecting national security and relations with the foreign state. Because when the government was asked, will you be providing us with the details about the Rafale deal? The government said we cannot share these details because it will affect the friendly relations with a foreign country, in this case France. Now let's look at another news article on page number 1. Election Commission puts on hold the biopic on Prime Minister Modi. There was a time when Election Commission was headed by T.N. Seshan, the legendary Chief Election Commissioner who single-handedly implemented some of the far-reaching reforms in the electoral process in this country. And it was during the tenure of T.N. Seshan in the early 1990s that Model Code of Conduct was improved and expanded. But now we are witnessing blatant misuse of this Model Code of Conduct, and it seemed that Election Commission of India is not in a position to punish those violating this Model Code of Conduct. We have seen people and candidates asking for votes in the name of religion, candidates asking for vote in the name of armed forces. We have seen candidates asking for votes in the name of caste, and despite all these blatant violations, Election Commission of India is not in a position to implement Model Code of Conduct in its letter and spirit. But now there are commentators who say finally Election Commission of India has woken up from the slumber. It has banned the release of the biopic on Prime Minister Modi, stopped the beaming of Namo TV and other surrogate propaganda. And what is this surrogate propaganda? If a candidate or a political party wants to propagate its ideology, its manifesto, its claims, that is what we call propaganda, and they are free to do that. But if someone else does this on behalf of this political party, that is what we call surrogate propaganda. And this surrogate propaganda violates the level playing field, which is the single most important objective of the Model Code of Conduct. And it is on this ground that EC has put on hold the release of the biopic on the Prime Minister Modi. And what is this Model Code of Conduct? We have discussed in detail in the past. In the video description below, I will provide you with the link to the lecture on Model Code of Conduct. Please go through that lecture. You will understand everything about the Model Code of Conduct. Now let's look at another news on page number 1. In yesterday's newspaper analysis, I told you that the British government has decided that we will not issue a formal apology regarding the Jallianwala Bagh massacre because we have to consider the financial implications of the same as well. Now the British Prime Minister Theresa May has expressed her regret for Jallianwala Bagh firing, and you need to understand that on April 13 it's going to be 100th anniversary of Jallianwala Bagh. So Jallianwala Bagh can be a potential question for your prelims examination. But there are people belonging to the Labour Party in United Kingdom. They are asking that regret will not serve the purpose. The British Prime Minister should issue a formal apology for what it did in April 1919. That is what you need to understand from this newspaper article. Now let's look at some international news. Benjamin Netanyahu is all set to be appointed as the Prime Minister of Israel for a record 5th term. And it's a good news for India as well, because under the Prime Ministership of Benjamin Netanyahu, the relations between India and Israel strengthened to a large extent. So there is a hope that this good relationship will continue under the 5th term of Benjamin Netanyahu. Now let's look at another news on page number 1 as well as 12 of the daily edition of the Hindu. Scientists have revealed the first ever image of a black hole. And what is this black hole? If too much matter is crammed into a particular place, the force of gravity becomes so strong that the place becomes a trap. And this trap is what we call black hole. According to Einstein, because it was through his equation that black holes emerged, according to Einstein, when matter, space and time come to an end, that space is what we call black space. And astronomers have announced that at last they have seen a black hole, which is a space from which even the light cannot escape. But there are some facts which can be important for your prelims. The term black hole was coined by John Archibald Wheeler. The first image of a black hole in a galaxy, Messier 87, it is in the constellation Virgo. And this black hole, the image of which we have seen for the first time, is about 6 billion times the mass of our sun. That is what you need to understand from this newspaper article. Now let us look at some of the editorials and columns from today's newspaper. First up, a column on page number 8, Trickeries of the Money Bill, written by Suhrit Parthasarthi. Now what is a money bill? A money bill has been defined under Article 110 of the Indian Constitution. It says a bill is a money bill if it deals only with money matters. A bill which deals only with the money matters is a money bill. Now what are these money matters? Article 110 defines them. So if there is a bill which talks about imposition of tax, alteration of tax, remission of tax, abolition of tax, such a bill is a money bill. If a bill tries to withdraw money from Consolidated Fund of India, such a bill is a money bill. If a bill talks about declaring an expenditure to be expenditure charged on the Consolidated Fund of India, for example, the salary and pension of the President of India, the salary and pensions of the judges of the Supreme Court, the salary of the UPSC chairperson, the salary of Comptroller and Auditor General of India. All these expenses are charged on the Consolidated Fund of India. That means Parliament will not vote on these expenditures. Parliament can only discuss these expenditures, but Parliament does not have the power to vote on these expenditures. And if a bill tries to declare another expenditure as charged on the Consolidated Fund of India, such a bill also would be a money bill. Because today, the salaries of election commissioners and chief election commissioner, they are not charged on the Consolidated Fund of India. So perhaps the only constitutional authority whose salaries and allowances are not charged on the Consolidated Fund of India. If tomorrow there is a bill which tries to say that the salaries and allowances of election commissioners and chief election commissioners shall also be charged on the Consolidated Fund of India, such a bill also would be a money bill. That means any bill, if it deals only with money matters, and which are these only money matters mentioned under Article 110, such a bill is a money bill. But there is one important clause at the end of this Article 110. Any other matter incidental to any of the matters specified above. And this was how Aadhaar was introduced as a money bill in the Lok Sabha. And many people argue that Aadhaar was not a money bill, because Aadhaar did not only talk about the money matters. Aadhaar also talked about biometrics. Aadhaar also talked about Unique Identification Authority of India. Aadhaar also talked about how the members and chairperson to UIDAI will be appointed. So Aadhaar did not only deal with these money matters, Aadhaar dealt with something else as well. So Aadhaar should have been a financial bill, or Aadhaar should have been any other bill, but it should not have been a money bill, because it was not only dealing with the money matters under Article 110. But Arun Jaitley, the finance minister, justified the introduction of Aadhaar as a money bill on the grounds that look at the G clause under Article 110. Any matter incidental to any of the matters specified above. He says that since Aadhaar talks about the dispersal of subsidies, the dispersal of benefits to the people of this country, but where will this money come from? This money will come from Consolidated Fund of India. And if the money comes from Consolidated Fund of India, that means it is a money bill. Because all other items in the Aadhaar bill, such as UIDAI, such as biometrics, they are incidental to the withdrawal of money from Consolidated Fund of India. That is why Aadhaar should be a money bill. But what was the real intention of tabling Aadhaar as a money bill? Because in money bill, Rajya Sabha has a very poor role. A money bill can be introduced only in Lok Sabha, that too with the previous consent of the President of India. In Lok Sabha, it requires simple majority. Once it is passed by Lok Sabha, it is sent to Rajya Sabha. Rajya Sabha cannot reject a money bill. Rajya Sabha cannot amend a money bill. Rajya Sabha can only recommend some suggestions or recommendations to a money bill. But if these recommendations are not acceptable to Lok Sabha, even then the bill is passed. And if Rajya Sabha does not act on this money bill for a period of 14 days, at the end of the 14-day period, the money bill shall be deemed to have been passed in the same form it was passed by Lok Sabha. That means Rajya Sabha has absolutely no role vis-a-vis the passage of a money bill. And since the government is in a minority in Rajya Sabha, government did not want that Aadhaar bill should be defeated by the Rajya Sabha. That is why some people argue that government introduced this bill in Lok Sabha as a money bill because the government wanted to bypass Rajya Sabha. And Constitution says under Article 110 that whenever money bill is transmitted to Rajya Sabha, a certificate should be attached to it. The certificate should be attached when the speaker should certify that the bill which we are transmitting to Rajya Sabha is a money bill. And Constitution said this certification by the speaker is final. When we say the certificate is final, that means we cannot challenge the decision of the speaker in the court of law. But then even this decision was challenged in the court of law when Jairam Ramesh filed a petition before the Supreme Court challenging the certificate of the Lok Sabha speaker certifying Aadhaar as a money bill. But government did not only do this. In the year 2017, when Finance Act was passed, and Finance Act is also a money bill after all, Finance Act is passed at the time of the budget because first the appropriation bill is passed, then finance bill is passed. This finance bill is also a money bill because there is a difference between a money bill and a financial bill. Money bill is under Article 110. Financial bill is under Article 117. But a finance bill is a money bill. So when this finance bill was passed at the time of the budget, what government did? Government changed the working of 26 tribunals or judicial bodies in this country. So the question asked was, how can government pass a money bill to change the working of 26 judicial bodies or quasi-judicial bodies or tribunals? Because such a bill can in no way be deemed as a money bill. Because money bill's definition is clear under Article 110. Any bill which deals only with money matters. But how can a money bill, in this case Finance Act, change the working and functions of 26 tribunals? For that there is a case pending in the Supreme Court, Revenue Bar Association versus Union of India, and this column argues that the judgment given by the Supreme Court in this tribunal's matter will have a profound bearing on India's constitutional arrangements. That is what you need to understand from this newspaper article. Now let's look at another article on page number 8, Forcing China's Hand, written by Harsh V. Pant. This is about the efforts of India and the global community to designate Masood Azhar, the head of Jaish-e-Mohammed, as a terrorist or a global terrorist. But China has been blocking all such initiatives, and at least 4 times in the past, China has used her veto to block this designation. And this newspaper article we don't have to discuss again because we have discussed such issues many a times in the past. Unless and until there is some forward movement, we should stop reading such articles on Masood Azhar. Now let's look at another column on page number 9, Algeria after Bouteflika. We have discussed 2 days ago how there were protests in Algeria and they wanted the ouster of Abdelaziz Bouteflika as the president of Algeria. Bouteflika was a member of the army when Algeria fought a national liberation war with France because France was the occupier of Algeria. Then there were successive governments in Algeria after the liberation of Algeria from France, and Bouteflika was a minister in some of these governments. But then there was also a civil war in Algeria between the Islamic militants and the government of Algeria. And then in the 1990s, Abdelaziz Bouteflika became the president of Algeria, and within 3 years, this civil war was brought to an end and economic reforms were implemented in Algeria. But there were allegations against Bouteflika that he is working in a dictatorial manner, in an authoritarian manner. There were protests now in Algeria, and these protests forced the resignation of Abdelaziz Bouteflika as the president of Algeria. But what is the link of what is happening in Algeria with India? That can be a potential question for your examination. It's important to note that President Bouteflika was a good friend of India. He had paid a state visit to India in the year 2001. So it is hoped that the successor of Bouteflika will also carry forward the legacy of the Algerian government. That's number one. Number two, bilateral economic ties are growing between India and Algeria. If we look at Algeria, it is a very important market for India. We export our food, we export automobiles, farm machinery, cosmetics, mobiles, pharmaceuticals to Algeria, and it is hoped that the next government in Algeria will carry forward the legacy of Bouteflika so that the economic cooperation between Algeria and India can be further strengthened. And it's important to note, point number 3, that Algeria is a member of Organization of Islamic Countries or Organization of Islamic Cooperation. But Algeria has consistently supported India's case against the terrorism. So that is why what is happening in Algeria will have an impact on India, and since it will have an impact on India, that makes it part of our civil services examination syllabus. That is what you need to understand from this newspaper column. There is another column on page number 9, Gubernatorial Impropriety. The Rajasthan Governor Kalyan Singh recently told the cadres of the BJP that we should vote and we should work harder to elect Prime Minister Modi again for the next term. Opposition political parties, they approached the Election Commission of India and also criticized Kalyan Singh because as a governor, you have to be impartial, you cannot be a party person. Election Commission submitted its report to the President, and the President has expressed extreme disapproval regarding the conduct of Kalyan Singh, the governor of Rajasthan, and has forwarded the letter to Ministry of Home Affairs, and now it remains to be seen whether any action can be taken against the governor of Rajasthan or not. So this column basically highlights that it is important to change the manner in which the governors are appointed and removed, so that these governors cannot act as the political stooges of the central government, because the governor enjoys a distinct constitutional entity in our constitutional setup. The governor is not the agent of the central government in the state. The governor cannot play partisan politics. The governor cannot play politics. The governor is a constitutional representative of the center in the state. And whenever there is a break of trust between the center and the state, it is the role of the governor to ensure that the trust carries forward between the center and the state. So governor's role is to strengthen cooperative federalism in this country. Federalism in this country. So governor should not be viewed to act in a partisan manner. There are 3 reports mentioned in this column. One is Sarkaria, Punchi Commission and Venkatachalya Commission. And it is important for your prelims examination to know what was the purpose of these 3 commissions. Sarkaria Commission was appointed in 1980s on center-state relations. Punchi Commission was set up by the UPA government in 2005, again on center-state relations. Venkatachalya Commission was set up for the review of Indian Constitution, or the review in the working of the Indian Constitution. So this can be a potential prelims-based question in your examination. Now let's look at some of the prelims-based questions. Number 1. Consider the following statements about SEBI, Securities and Exchange Board of India. It is a statutory body, yes, but initially when it got created in 1988. But a government resolution created SEBI. No law was passed for the enactment of Securities and Exchange Board of India. It was in 1992 that a statutory status was provided to SEBI when SEBI Act was passed in 1992. The SEBI regulates the equities markets and not the commodities markets. This statement is wrong because when in 2015, Forward Markets Commission, which regulated commodities market, when it was abolished, it was merged with SEBI. That means now SEBI regulates both equities markets as well as the commodities markets. Mutual funds in India are regulated by SEBI, correct? So which of the above statements are correct? C, 1 and 3 only. Let's look at another question. Multidimensional Poverty Index is released by United Nations Environment Development Program. Previous year's prelims based question 2018. India enacted Geographical Indications of Goods and Protection Act in order to comply with the obligations to World Trade Organization. That is it from our newspaper analysis for today. Thank you for being with us. Have a great day.